My lady, notwithstanding the efforts that the police, the conduct of the police, conducting the operation, permitting food, providing an alternative exit to these menace, having sent pamphlets to communicate them where they can get out, and others utilized it. Those who stay there, they don't want to, they basically refusing to get out. The applicant rushes to this court on an extreme urgent basis without any facts that illegal minors' rights to life and dignity are being undermined. The court asked a direct question: do you have facts to support what you're saying? The answer was no.
To what extent can I accept, because that was the argument of Ms. Omar, is that we know that our case law permits certain amounts of hearsay evidence in urgent applications of
Yes.
this nature. And that was her argument.
My lady, you see, when we're going to talk about hearsay evidence, what constitutes hearsay evidence is clear in terms of our law, in terms of what is hearsay evidence. And speculation is something different. So if we're going to say hearsay evidence is someone who says, well, someone told me this, and this is what happened. But that person, for other reasons, is unable to come to court to say, well, yeah, to confirm the probative value of that statement or of those facts. In this instance, it's not the case. It's a case of, I read on the media. It's a case of, there's a report by this union. It's a case of, there's a statement from the newspaper. There are no facts to support what they seek. And it's not, hence I'm saying, it's not even hearsay. Hearsay is higher than that. What is here before the court is just pure speculations. My lady, I submit that the police operations in these circumstances to continue with their operation should not be interrupted. Let the police be permitted to continue with the operation, and that's it. And until such time that we are told that the police are doing anything outside the law, then that can be looked at. In fact, my lady, now that on paragraph 31 of the fourth respondent's answering affidavit at 88-10, which I'm going to go to now. I'm just going to deal in detail with the requirements for interim interdict. But what I just want to state then is, in that paragraph, it reads that in this case, the conduct of illegal minors to refuse to exit through Margaret Shaft, but insisting on exiting via Stilfontein mine shaft, which is considered unsafe, is voluntary assumption of risk. I will deal with it in a moment in terms of what that means. And it continues to say, the use of Stilfontein shaft will prolong the rescue operation up to months, whereas the use of Margaret Shaft will take few days. So if all the illegal miners that were there, they were saying, we are trapped, we wanted to get out, they would have been out by now. The reason that mine rescue operations were called to come to the place, it's not because they are trapped, illegal miners, but they are there to enforce the operation of the police, to ensure that everyone that is there is brought to book. It's not that they are trapped people or trapped illegal miners who can't come out.
But that's not the case in the answering affidavits. The case in the answering affidavits is that mine rescue operations have been called in to assess the safety of the use of the Stilfontein mine shaft, so that the rescue operations, in addition to the Margaret shaft, can be carried out through Stilfontein shaft.
Precisely, ma'am.
Yes.
Precisely, ma'am.
But the case is not on the basis of the operations. The case is on the basis of an extraction. To make that shaft, which is over 2 kilometers deep and hazardous, safe for those to not only enter, but in other words, the emergency workers, but those who are trapped there, if we want to use that word, to exit.
That is true, my lady. Then I'm going to go back to a bit in terms of how the operation Valumgodi works. Operation Valumgodi, which is led by the police. Just go to that specific paragraph. The police, my lady, in conducting that, I want to deal with this. On paragraph 17 of the second respondent answering affidavit, which is 00-6, says Section 205 of the Constitution mandate the police to combat and investigate crime. Illegal mining has become one of the prevalent crimes in this country. Thus, in response to this, the police have adopted Operation Valumgodi, which is intended to prevent and combat illicit mining and criminal activities in mines across several provinces, supported by the fourth respondent, regulatory compliance and security infrastructure. So that MRS is one of the agencies which the fourth respondent utilizes in case where there are emergency, where there's an emergency that has occurred in the mine. So when they went to the mine there, it's because it's still a continuation of Operation Valumgodi. So hence I'm saying that their presence there, they did not come there because it's a mine of people that is there and people are trapped, but they came there to assist in the operation. My lady, then the next thing that I want to deal with is we know that what the applicants seek in this case is a mandamus. And for a mandamus to be granted, there are certain requirements in law that must be satisfied. And our position in this case is that the applicant has failed to satisfy the requirements of an interdict. In fact, the applicant faces an insurmountable difficulty in its quest for this order, because it is tried that as a matter of law, interdict is a remedy of invasion of rights, whether past or present. And that invasion of rights it has to emanate from facts to say this is what transpired. And in this case, we do not have any affidavit claiming miners to be trapped underground, that their right to life, dignity, and health was or is undermined by the respondents, or that they have instructed the applicants to come to court to seek relief on those rights. As we stand today, we don't know who briefed the applicant or who mandated the applicant to institute the application.
But the applicant is how can they are similar to a Section 27 or the Helen Suzman Foundation, or that's how I understand it. So they can approach court as an interested party.
That is so, my lady. If you satisfy or if you meet the requirements of Section 38 of the Constitution, they have not said in this case that we are acting on behalf, or we've brought this application on public interest, we're acting on behalf, and so based on this fact. There is nothing. All they say, but we'll deal with that. Let me continue with my argument. I'll come with the issue of locus. I want to finish this point before my thoughts get distracted. So, my lady, then we submit, what we say is that if there is no fact supporting that minors are trapped, their rights to dignity are violated, then what is the logic of granting a mandamus without, when there's no evidence to support the prayers that they seek? And when the police are conducting an operation and it has not been shown that they're acting outside of the law, the rule of law must be respected. It has to be respected by all. My lady, and a test for an interdict was set out by a court in Webster versus Mitchell. It's a well-known case. I'll just read the paragraph because I want to make this point. The test is to consider the facts set out by the applicant together with any facts of the respondent, which the applicant cannot dispute, and to consider whether, having regard to the inherent probabilities, the applicant could or should, which was later turned by the case, should obtain the final relief of those facts. In this case, what are the facts that are set out by the applicants? They have no direct facts that minors are trapped. There is nothing. And the court, my lady, in the outer case, in fact, the Constitutional Court, at paragraph 45, said the following with respect to a test for interdict, that it seems to me that it is unnecessary to fashion a new test for the grant of an interim interdict. The Sikolo test, the Sikogelo test, as adopted by case law, continues to be handy and ready to guide the bench and practitioners alike in the grant of interdict in busy magistrate courts and high courts. However, now the test must be applied cognizant of the normative scheme and democratic principles that underpin our Constitution. This means that when a court considers whether to grant an interim interdict, it must do so in a way that promotes the object, spirit, and purpose purport of the Bill of Rights, of the Constitution. The Constitution mandates the police to do investigations. It's there in the Constitution, so that they cannot be stopped. In fact, the court say the law says they can only do so in the clearest of cases, where you can interdict the statutory obligations. You can do in the clearest of cases, where a proper case has been set out. This is not one of those cases. My lady, on the other hand, what the second and fourth respondent in their answering affidavit have demonstrated is the following. That one, the police are running an operation. Two, that there are no legal minors that are trapped, and those that are there, they have remained because they are evading arrest. And that the illegal minors were informed to utilize Margaret Main Shaft, which was made as an alternative. There were pamphlets which were spread, which were circulated. There were meetings which were held with community leaders, with illegal minors leaders, to say everyone must, but they still decide not to utilize it. Those who utilize it, we have almost 1,200 who utilize and are out. And all those ones who are out, they have not said their rights have been violated by the police. And in any event, my lady, Regulation 16.5 of the Mine Health and Safety states that whenever an emergency occurs that requires deployment of mine rescue teams, the mine employer must take all reasonable rescue measures to ensure that the required mine rescue teams are deployed as soon as possible. In this case, the applicant has failed to join the mine owner. The mine owner, we're not saying the mine owner has, we understand the applications of the rights in the Bill of Rights, but what we're saying is that they have an obligation in terms of the law. So if there was an issue of emergency personnel that needed to be sorted, or that were not sent, or emergency relief that needed to be done earlier, or that was not being done at all, they were supposed to come to court to say, what have you done? You have this obligation in terms of the law, but they're not cited. In the premises, my lady, first I submit that the applicant has failed to demonstrate that they have a prima facie right, let alone a clear right in terms of the law. And the second part I want to deal with is that there is no harm or irreparable harm that may befall the applicant. An applicant for a temporary or for an interdict must show a well-grounded apprehension of harm that if the interdict is not granted, the harm will occur. And in this case, I submit that the alleged harm by the applicant based on the right to life, dignity, and health cannot be sustained. It cannot be sustained because it's not based on facts. And if the concept of harm is directly linked to prima facie right or a right. And if there is no right to the mandamus or to the interdict, there can be no harm. In this instance, my lady, I submit that the applicant has not demonstrated that illegal minors' right to life, dignity, and health has been undermined by the respondents. In fact, my lady, we submit that we've already made the submission that there is a safe exit which has been made available, and they are not utilizing it. And the one at Stilfontein shaft is still being assessed because of the many risks that are there. My lady, the fourth respondent has already told the court that the use of Stilfontein, which I've made this point, that it will prolong this rescue operation. So if this thing needs to be done quick, or within a few days, Michael Shaft is there, they can utilize that. And if any of them that is down there and refusing to come out allege that their rights have been violated, they can come out, they can approach the applicants and issue, and the matter can be taken from there. And the experts, my lady, who are trained, which is MRS, Mine Rescue Services, have it's been stated that in the past, where they've lost some team members when they go down there, so it's important for them to conduct a proper assessment. And that proper assessment, because there's a risk to life to it, it cannot be rushed. We cannot say, well, do it. It's important that a proper assessment is done to prevent harm or a loss of life. In the circumstances, my lady, I submit that no harm. It has been demonstrated that no harm can be suffered by the applicant if this application is dismissed, because there is an alternative exit. And the other part I want to deal with is the balance of convenience. We say in this case, the balance of convenience favors the respondent. An applicant for an interdict is required to demonstrate that the balance of convenience favors the granting of the interdict. The Constitutional Court in the outer case, my lady, at paragraph 46, has held that if, and it's quoted on paragraph 68 of 46, the paragraph of the case is 46, is 68 on my heads of arguments. It says that if the right asserted is in claim for an interim interdict is sourced from the Constitution, it would be redundant to require whether the right exists. Similarly, when a court weighs up where the balance of convenience rests, it may not fail to consider the probable impact of restraining order on constitutional and statutory powers and duties of the state functionary or organ of state against which the interim order is sought.
Sorry, just give me the paragraph in your heads again.
68, my lady.
Thank you.
So in this instance, what we are saying is that the police, they have a mandate in terms of section of 208, 205 of the Constitution, sub 3, which mandates them to investigate, to conduct this operation. And that right, my lady, it cannot be restrained. It can only be restrained where a proper case has been set out, or in the clearest of cases. And we say there's none here. And when, on the other hand, what constitutional rights do the applicant or do the illegal miners have to be conducting, to be evading arrest, to be in a mine where they are not supposed to be receiving explosives, firearms, alcohol. Where is their right based? Is that the rule of law, my lady? It has to be respected by all. At the center of the rule of law is that whether you are a suspect or the police, the rule of law must be respected. And in this case, it has not been demonstrated that the police have not been respecting the rule of law and that they've been acting outside the ambits of the law. There was a submission, and in fact it's also stated that, well, one of the legal miners was pulled out dead. That, it is unfortunate, my lady. But it being unfortunate, you cannot say because a person is pulled out dead, that was directly linked to the conduct of the police. An autopsy has to be done so we know what's the cause of death. But it cannot be assumed that it's the conduct of the police. That can't be. And in any event, we don't have any evidence to suggest that this individual died because the police did this. It can't. There's an assumption that, well, the police died of starvation because of the police, but there's no report to support what you're saying. There are no facts to support that. So I submit, my leader, the presence of the police there is mandated by the Constitution, and on the contrary, the illegal miners are committing criminal acts, and their continuous presence underground is frustrating the proper administration of justice. To this extent, MRS has been engaged to assist in pulling, in extracting the miners, and in the meantime, those who want to get out, Margaret mine shaft has been made available, and there's no evidence that they can't reach there or that they can't utilize it. And my lady, the last part of mine shaft being made available is linked also to the requirement of the fact that the applicant have an alternative remedy. They have an alternative remedy because to date we have close to or almost 1,200 illegal miners who were able to come out. And those who came out, there is no evidence from them who says that we were unable or our rights were violated or that we were trapped. That evidence is not there. So it is on this basis that we submit that those who remain there, they remain there because they are evading arrest and because of their own violation. And in this respect, we submit that no case has been made out by the respondents insofar as the mandamus is concerned. But also, my lady, the important part that I just wanted to, which I touched on, is the failure to join the owner of the mine. Regulation 16.5 sub 4 of the Mine Health and Safety is specific on what should happen in cases of emergency. We are not told that they've approached the mine owner who said, well, I can't assist because of 1, 2, 3, 4, 5. There are absolutely no facts. In fact, to put it blank, my lady, the applicants have done nothing to get the facts to bring this application before the court. All that they've done is to get reports from the media or to listen to statements which are made on the media. But there are actually no facts on what's happening on the ground, on what's the conduct of the police, on what's the treatment that is being received by the illegal miners. There are no facts to support what they seek. My lady, the court in the city of Johannesburg Metropolitan versus Blue Moon Light confirmed that a party must be joined in proceeding if it has a direct and substantial interest in any order that the court might make, or whether and when an order cannot be effected without prejudicing it. So we submit that the orders of emergency relief in this instance, the mine owner has an interest, and they ought to have been joined in this instance. and their failure to do so, and the applicant's failure to join a party that has a direct and substantial interest, this court must show its displeasure and dismiss this application, alternatively strike it off the roll on this ground alone. The last part, my leader, that I just want to deal with is the issue of standing of the applicant.
But that's not in your papers.
It's a point of law, my lady. My lady, the applicant, what they say in their in their papers, just want to go to the specific. In their founding affidavit, at paragraph 8, it says the applicant is a voluntary association with perpetual existence. 9, a primary objective of the applicant is to uphold, protect, and ensure that the rights enshrined in Chapter 2 of the South African Constitution is upheld. Ends there. Then they continue to say there are 4,000 illegal miners, but there are no facts to say who they are acting for. Where do they get the facts that miners are trapped? So we don't have those facts. There are no facts who told them, there's no evidence even to date to the court say these rights have been violated by the respondents. So we don't know what gives the applicant standing to bring this application. We're not saying they're not entitled to, but we're not saying civil litigants are not entitled to bring an application against the state. Of course they are, but what we say is that when you bring an application, at least there must be a basis of facts. Someone must have said this and this happened. Or
but that's different from locus standi. That goes to merits. Locus standi goes to standing. The standing, they attach their constitution. In terms of paragraph 004-10, they say, in Roman 2, the society will take all necessary action, legal or demonstrative, or such measures as its members may from time to time deem fit, with the aim of preventing violations of the Constitution. That's their standing. The facts upon which they base it, according to your clients, have got no basis. So that's a completely different issue because that goes to merit. But on what basis do they not have standing to bring this application?
My lady, that is what their constitution have said. And in this instance, what we do not have is that, well, their members, if we are going to go with that interpretation, their members have said, we have resolved that this organization or this voluntary association is going to bring this application or bring an application against the state on these grounds.
No, but I understand your submission, but I think your submission is a bit convoluted. Because the whole purpose of a voluntary association is, if you look at the Constitution, is they've got a governing body. And I'm using the term loosely, to make the decisions on behalf of the members. Are you saying because there's no resolution of the governing body or executive or whatever you want to call it, that therefore the society doesn't have standing? Is that the submission?
My lady, my submission is that there are no facts to support the application that they've brought.
No, but that's different.
Which
that goes to merits.
I accept.
You understand?
I understand, my lady.
Yeah. Okay.
I understand, my lady. My lady, what I want to bring the part which I'd my lady, we submit in this instance that the applicant's application must be dismissed. It must be dismissed with cost. And that, my lady, they've failed they've not made out a case for the relief that they seek, more so because we've demonstrated that the illegal miners have, the police are acting within, insofar as the constitution that mandates them, and they have not undermined any right of any illegal miner. They've made available an alternative exit, and that the miners who remain underground, they remain there because, not because there is no exit, and not because they are trapped. They remain there because they are evading arrest. And
What's with costs on which scale?
my lady, cost must be on scale C. As the court pleases, my lady. That's my submission.
Could I ask you a question? And please don't misunderstand me. I don't mean to constrain you time-wise at all, but I have two other very urgent applications I need to deal with today. Unfortunately, they can't stand over until tomorrow. Could I ask you, more or less, do you think you'll be done by lunchtime?
What time is this at?
If you
Oh,
need another-
definitely. My
If
response
you
is
need
very
another 10
short.
minutes, that's fine.
Yeah, no, but I'm going to be very short. There's
All
not
right.
so much that
Please
we need to
continue.
reply to.
Thank you.
As the court pleases. My lady, the respondent hasn't taken a definite stance about what is going on underground. The applicant is saying these miners are trapped underground and that the respondents are in control of the situation. It's common cause that there are people underground. And it's also the respondent's version that we are providing the food and water supply to them. Respondents are also saying we are the ones doing the rescue operation. So it is evident that while respondent is not saying definitely these people are being detained by us, all of the circumstances and all of the facts that we've alluded to clearly indicate this is an operation and the people there are under your control. To tell the court, but these people are not trapped, is mischievous because the respondent fails to address what the applicant has put before the court. Applicant is telling the court, look, you've contained these people in there. You've pulled out the pulleys and the systems put in place by the community and maybe even the miners to get them out of there. And you are looking to third parties to do an assessment of how to get these people out. The very fact that there are no measures there for them to now simply walk out, they've told you already, this thing is so far down, it's not a situation where miners can simply walk out. Then it requires, even on the respondent's version, some kind of skilled mechanism to pull those people out from underground. So it is not the complete truth to say this is just a situation where people are just sitting underground waiting to avoid arrest. Nobody would want to be in those circumstances, my lady. My learned friend accuses the applicant of speculating. But one must ask, how does the respondent comfort itself with telling the court the people are only sitting there and refusing to come out because they don't want to be arrested? How can the respondents comfort themselves, not knowing what the condition of the people are, when the applicant is contending directly that these people have been starved and they have not been getting adequate care until this application was pursued? And even so, we still submit it's not adequate care. How are the respondents comforting themselves that these people don't require basic essentials? Even now, the respondents are not coming to court to tell the court, well, let's reach some kind of compromise because we are doing that which is necessary. They're saying simply dismiss this application. Now, my learned friend referred the court to the allegations that these people down there are criminals. In fact, according to the deposition of, I think it's I just want to refer to that page. According to the deposition of the second respondent, which my learned friend was talking to the court about the seizure of alcohol generators, and they pin the date. Whereas in all the other paragraphs, there are no dates. There's no reference to dates and when the things were being done. But when you look at paragraph 19 of second respondent's answering affidavit, he deposes that around 15 November 2024, the police prevented community members around Stilfontein mine shaft who wanted to deliver alcohol generators and unlawful firearms to the illegal miners who were refusing to exit. Now, my lady, it's common cause that on that date, the mine was already surrounded by police. At that time, the police presence was already there. That's when this application was pursued, on the very same days when the founding affidavit is signed. Let's look at what the respondent responds to paragraph 19, and that's applicant's replying affidavit to second respondent's answering affidavit. It's paragraph 36 of their affidavit. The contents of that deposition of the second respondent is denied. And the applicant says on the 15th of November 2024, the entrance of the mine was already blocked by police. Why would the community bring to the entrance of the mine the items referred to herein when it is common cause that the place was under police guard? Now, respondents are contending on this day, with all of that police, with all of those SANDF there, the community brings these illegal items. On the probabilities, that never happened, my lady. Now, my learned friend also told the court that these are not helpless miners. My lady, do we have to reach a stage where people kept like this underground must reach the stage where they are so helpless, and only in a state of complete helplessness will government intervene? The miners underground, the applicants' cases, are not being given basic necessities. That's their case. It is not going to help for miners to be kept there and denied essentials, and for the police to say, well, we're giving them sporadically food. We don't know what measures, what amounts. That is not elaborated upon by the respondents. They don't say, but look, applicants, you are crying unnecessarily. There is sufficient food going down to them. We know we've contained them there, but we've given them sufficient. That is not what is the case of the respondents. Then, my lady, the aspect of the sealing of the mine shaft, the applicant's case has continuously been that you are blocking the mine shaft. You are sealing the entrances. And that is in keeping with what government has already said. They said, we are valam godi, we are closing the hole. And we're going to keep them there and smoke them out for the purposes of persecution, according to the minister. Then, in respect of the movement of the people through Margaret Shaft, and my lady will see that deposition at paragraph 23.2 of the second respondent's answering affidavit, my lady.
Sorry, paragraph?
23.2, yes. And what my lady will notice from the, when compared to the affidavit of the fourth respondent, and my learned friend referred the court to the fourth respondent's affidavit, where they say, well, at some stage we discovered there's we will read that alongside paragraph 13 of the fourth respondent's affidavit, my lady. So if you look at the two affidavits of these two respondents, at paragraph 23.2 of the second respondent's affidavit, he says, the illegal miners have an alternative exit which is made available, and more than 500 illegal miners have utilized Margaret Shaft to exit Stilfontein. In fact, to date, there are 1,187 illegal miners who have resurfaced and been arrested. Thus, this clearly shows that Operation Vala Mgodi does not prevent illegal miners from exiting Stilfontein mine. What is lacking in this is to indicate when did that removal happen? When did these 1,187 people, when were they extracted? In the replying affidavit of the respondent, the replying affidavit said, yes, we could move out at that stage. We could get the miners out. Because at that stage, the pulley system was still in place. And that is contained at paragraphs 28 and 42 of the respondent's replying affidavit, my lady, to the second respondent's answering affidavit. So, if my lady looks at paragraph 28 of the replying affidavit, and it is a portion that my lady canvassed when she debated with my learned friend, that in the last few lines it indicates the police, however, stopped the extraction of the people underground by the community. There is no means for the miners to exit the mine without the equipment that had been set up by the community or other appropriate equipment. And if my lady looks at paragraph 42 of the same affidavit, you'll see it's elaborated upon a little more. It says, those that have exited the mines have done so with the assistance of the community, who employ their own police system to pull the people out. The police have removed this infrastructure and have refused to allow the community to draw people out. It is noteworthy that the police indicated that they do not have the infrastructure or the manpower who will go down into the mine and draw the people out. The community themselves were willing to draw the people out. Had the police really wanted the people underground out, they would have allowed the community to pull them out and arrest them after they had surfaced. So it is evident that the respondent's suggestion, well, there's just another shaft, use that shaft, it's impractical because they don't tell the court, well, look, it's been set up, we've put the ropes in, we've got the personnel, and we're willing to pull them out. In fact, they say quite the opposite. They say we can't help pull people out because we don't have the infrastructure. Now, my lady, the argument was also put to the court, but these people who are underground should not have been there. They don't belong there in the first place. Now, my lady, that misses the point. Even if they are doing wrongdoing, and this was a case of the applicant, even if they are doing wrong, even if they are working illegally, whatever may be the situation, even criminals in the country have basic human rights. Those rights are guaranteed. And we say those rights should be respected, even if the state perceives their conduct as illegal. Then, my lady, in respect of the aspect of locus standi, I trust my lady has debated that with my learned friend. Yes. Thank you, my lady. My lady, then the respondent's case is, and that has come out of the simply of the address of the court and the proceedings in court today, that there is no direct evidence. But in this case, there is substantial indirect evidence of what is going on in the form of the media presentations and what has been going on in the country over the last week. The public outcry that there have been transgressions. In addition, my lady, the contents of the founding affidavit have not been denied. My lady, my learned friend asked the court what constitutional right do the miners have. They have the same constitutional rights as everybody else in the country, and we are asking that those rights be respected. Then, my lady, lastly, regarding the joinder of the owner of the mine, my lady, there's no obligation on the owner of the mine to do anything here because the owner of the mine didn't create the situation. It is a policing measure on the respondent's own version, and they are the people responsible to ensure that the people on the ground underground are taken care of. I wish to draw the court's attention also to the fourth respondent's answering affidavit, my lady. I just want to give the relevant paragraphs. Yes, the fourth respondent's answering affidavit, and that's at paragraph 10 to paragraph 12. in respect of the involvement of the owner of the mine. And just a quick read of it, it says, in the case of emergencies at the mine, the mining sector relies on an organization called Mining Rescue Services. This is a service provider contemplated in Regulation 16.5 of Act 29 of 1996 for attending to emergencies at mines. As such, in case of emergencies in an operative mine, the owner of that specific mine will engage with MRS to come and do an assessment. Where MRS is of the view that it is safe for them to conduct their operations, they will come with their equipment to carry out such operations. However, in a case of non-operational or ownerless mines, the fourth respondent will engage the MRS to come and do the assessment. This is because government does not have the capabilities to conduct mine rescue services. And he goes on later in the affidavit to say that we have contacted MRS and we are doing it. So it's a hollow defense to say, well, call upon the owner of the mine, because it's clear that on the fourth respondent's own affidavit, having taken the next level to engage MRS, that this appears to be a non-operational mine, and the owner of the mine would have no responsibility, and on fourth response version, it's the responsibility of government. My lady, unless the court has anything else that it wishes to ask, that is the response of the applicant in respect of the assertions of the respondents. I thank you, my lady.
Thank you all. Obviously, this matter is extremely important, and I am going to reserve judgment. It will be handed down by no later than Monday morning. I am still trying to decide whether I will deliver it or email it.
Thank you,
My
madam.
secretary will notify you all by, let's say, lunchtime tomorrow, whichever you wish.
Thank you, madam.
Thank you, my lady.
Thank you all. I'm going to take a very brief adjournment so that I can allow the court to be cleared, and then Mr. Ferrara, your matter I will deal with now, as soon as they are out. Thank you. Court will adjourn.
Look at it, KH, and Applicant.